Hello, everyone, and welcome to Uncivil Law. Today's case isn't about an attorney gone bad. This is a case from the United States Court of Appeals for the First Circuit. In Re Donald Kupperstein. In this case, Donald purchased a home. He did so on shaky grounds, one might call them fraudulent grounds. And although ordered to turn over the house again, he has not done so. He maintains the house despite multiple contempt citations, multiple arrest warrants, and him being a fugitive from justice. So we're going to read all about this attorney and this house sale gone wrong, and how this attorney is behaving in not such a great way, making attorneys look bad. So let's get started with this. 5 years ago, Thomas Seedy brought Carol Thiebaud's house for pittance and gave it to appellant Donald Kupperstein, an attorney licensed in Massachusetts. The state court reversed the sale, but Kupperstein began collecting rent. So you see what happened here. One guy purchased the house from another guy and then turned it over to his attorney, who now holds the house. And even though the state has reversed the sale, he just holds on to the house. Okay. So far, this attorney has defied 7 state court orders, 4 arrest warrants, and a mountain of contempt citations. He has fled to bankruptcy to ward them off, hoping the bankruptcy's code automatic stay would stop the state court from enforcing its orders. But the bankruptcy court lifted the stay, so Kupperstein skedaddled while his lawyer appealed. The lawyer's lawyer is appealing. Massachusetts asked the judge to dismiss the appeal based on the fugitive disentitlement doctrine, the rule that a fugitive, normally a criminal one, forfeits the right to an appeal of judgment, usually the conviction he's fleeing. The district court agreed and dismissed the appeal. Kupperstein's serial misconduct and contempt for the state courts trouble us, and his victims argue, fairly, that bankruptcy code doesn't shield them from his comeuppance. But the district court never reached the issue. It booted the appeal prematurely. Because of this, early dismissal was an abuse of discretion. We reverse and remand. So even though the attorney is behaving very badly, currently has multiple arrest warrants, he sent it back to district court for further due process. So I guess it shows that even scoundrels get due process. So I guess that's a good thing. But let's read more. Of course, we can't let a story like this go on without discussing the factual background of how we got to this wonderful, wonderful place. When her father died, Carol Thiebaud was left with only one significant asset, a house in Norton, Massachusetts. Unfortunately for Thiebaud, Coon's estate also owed approximately $191,000 to the Massachusetts Office of Health and Human Services, more commonly known as MassHealth. For the uninitiated, MassHealth can recoup paid benefits from a recipient's estate after he dies. I don't know anything more about Massachusetts health policy than was just told me in the court, but if it's really the case that Massachusetts Health can come after you after you're dead for all the money they spent on your care, one kind of wonders what the point was in the first place. But apparently it's the law in Massachusetts, so let's pass on. The state had long ago placed a lien on Coon's house to secure the debt. After Coon passed, Massachusetts planned to have Thiebaud, who was also the estate's personal representative, sell the house, which was worth $168,000, to pay off the lien. One takes note that means the house was worth less than the health authority wanted, so that's a nice little touch. Enter Kupperstein and his associate, Thomas Seedy, who had other plans. In November 2014, they showed up at the home with a sales pitch. First, they had bad news. The state owed the town of Norton $3,379 in unpaid real estate taxes. Not to worry, they could help. All she had to do was hand over the house to Seedy, who would take care of those taxes, and Thiebaud properly agreed. This is like a Nigerian scam taken up to 11. So rather than, hi, I'm your dead grandfather, or hi, it's the IRS, hi, I'm an attorney and you owe $3,000 of taxes, but if you sign over your house to me, it'll be all okay. And apparently they did that. So that's not in any way suspicious. Yeesh. And so, without notifying the estate's attorney, Kupperstein notarized a deed that conveyed the property to Seedy as a trustee in exchange for less than $100 and a tax redemption of the amount charged. Unbeknownst to Thiebaud, the deal was against the law, as the probate court would later hold. She could not sell the house without paying MassHealth's 6-figure claim. When McCall discovered what happened, he, in the probate court, requested Mr. Cooperstein and Mr. Sheedy to return the property to the estate of Mr. Kuhn due to the improper need, and the duo refused. So began a 5-year campaign to wrest back control of the house from Sheedy and Cooperstein, who dug in their heels. When McCall told Mass Health of the house swap, Mass Health sued the pair in Massachusetts State Court. After a year of legal wrangling, the probate court voided the transfer to Sheedy, restored the property to the estate, and ordered its sale to pay Mass Health. The court also ordered that Cooperstein and Sheedy account for any and all rents they collected from the property. So the probate court, which is the court that deals with wills, trusts, and other kinds of decedent's assets, this court said, no, this was an improper sale, so you have to give us back title of the property, and you also have to account for any rent that you got, which was improper. So give us back the property, give us back the rent. And of course, him being a good attorney, he immediately complied. Or perhaps the exact opposite of those things? Earlier said than done, it turns out. Within a few months of the probate court decision, December 2016, Sheedy had leased the house for around $1,800 a month. Midway through 2017, Sheedy paid off his claimed ownership to Cooperstein as the trustee and benefit of the Norton Realty Trust, who kept collecting rent. All in all, Sheedy and Cooperstein raked in at least $54,750 in rent from tenants. Despite the district court's order, they gave none of it to Mass Health or the estate. We're in contempt of a court order and collecting $4,000 we don't actually have right to. That's just great. That's good news for an attorney. And so, on August the 4th, 2017, the probate court held the two in contempt, to no effect. Less than a month later, Cooperstein had installed 2 new tenants, who leased dubbed Cooperstein Trust the fee owner of the property and charged them the same $1,800 monthly. The probate court issued a decree that neither Thomas Sheedy nor Donald Cooperstein shall execute or record any further documents concerning the property, and that any documents that they executed were without force and effect. Unsatisfied with how the probate proceedings were going, Cooperstein sought a second opinion. He sued Thiebaud in the Massachusetts Land Court, asking him to declare him the house's rightful owner. In the filings, Cooperstein forgot to mention the probate court's decision. Courts really love it when you do that, when there's already a judgment from one court and you fail to mention that in your pleadings to another court. That's the kind of thing courts just really, really love about. So top marks. Playing legal whack-a-mole, Mass Health intervened to educate the land court, which dismissed the complaint as wholly insubstantial and frivolous because he completely ignored the probate court had already fully and finally adjudicated the title to the property against him. The land court is also against him. The court concluded that Cooperstein bought the estate in bad faith and awarded Mass Health and Thiebaud over $9,000 in attorney's fees. This is where the attorney begins to comply. The next day, the probate court doubled down, finding Sheedy and Cooperstein in contempt again and ordering them again to cough up the rent they collected. It also ordered them to surrender all keys and other means of access to the house, along with any documents, leases, or other instruments to the estate by the close of business, and threatened to jail them for 30 days unless they paid Mass Health $5,400. In response, Cooperstein and Sheedy surrendered roughly $3,000 in checks, but not the key or the lease. That's not exactly what you were asked for. Losing patience and without being asked, the court directed the pair to explain why it should not impose the 30-day jail sentence. It scheduled a hearing for January the 12th on 2018. And that's where the fear of God was put in the attorney? On January the 11th, 2018, the day before the hearing, Cooperstein filed this case in the United States Bankruptcy Court for the District of Massachusetts, leasing the house as an asset worth over $350,000. We just don't learn. First of all, the house wasn't worth that much. And second of all, fleeing to yet another court. Just again, things courts just love. Some background. A bankruptcy filing triggers an automatic stay that halts lawsuits against a debtor in other courts until a federal court enters this case or lifts the stay. At his hearing the next day, Cooperstein claimed the automatic stay tied the state court hand so it could not sanction him for failing to produce the rent and keys. I have to admire him for his creativity in his argument. He went off to federal court in bankruptcy. He filed a bankruptcy. It includes an automatic stay. And then the next day he went to state court and said, nah, you can't sanction me because there's an automatic stay, so you have no power over me. Wow. probate court didn't see it that way. You don't say. It held that Cooperstein had violated its orders a fourth time, locked him up in a holding cell for the rest of the day, then gave him another chance to give the house keys, though he claimed he didn't have it with him. At the next court date, in March 2018, after retrying the automatic stay argument unsuccessfully, Cooperstein pulled $5,400 in cash from his pocket to purge the contempt. He also produced a set of keys. So he's finally beginning to comply? Of course not. Then, Cooperstein went AWOL. Excellent. The court held him in contempt twice more for snubbing his next 3 court dates, as well as the court's previous orders. To sum it up, the court wrote, in violation of his orders, Cooperstein and Sheedy had swapped and leased the house, installed new tenants, changed the locks, trespassed, listed the property as a personal asset on the bankruptcy petition, and withheld $54,750 in rent. The court ordered Cooperstein and Sheedy to pay MassHealth the outstanding rents, plus, as sanctions, $10,485 in attorney's fees and $70,289 as statutory interest on the unpaid Medicaid claim. It also warned that they'd be arrested and jailed for 30 days unless they worked with MassHealth to agree on a payment plan. To date, Cooperstein has still not complied with those orders, and the probate court has issued 4 warrants for his arrest. Despite several attempts to locate and arrest him, once at his last known address, he remains at large. During the one attempt, the sheriff reported that Cooperstein's house has closed up and abandoned with furniture covered in clothes. This attorney has gone way off the reservation. Why stay on defense when you can go on offense? Health petitioned the bankruptcy court to grant them relief from the automatic stay so the state court actions could proceed. Cooperstein's counsel shot back with a motion to hold MassHealth in contempt. Let's take note of what just happened there. Cooperstein, the attorney who has been held in contempt multiple times and has 4 arrest warrants for him, his attorney filed a motion for contempt against MassHealth, arguing that by asking the probate court to hold Cooperstein in contempt and litigating other motions in that court after the bankruptcy filing, the agency violated the automatic stay. So his attorney is arguing that their attorney violated the rules of the bankruptcy court by asking for contempt in the state court. Wow. I admire this guy's cojones, I have to say. While the motions were pending, the bankruptcy court granted Shaloff partial relief from the stay to finally sell the house, which she did. So at least after this drama, the house has been sold, so there's that going for us. On August the 13th, 2018, the bankruptcy court ordered that all 3 state court actions in Superior Court, Land Court, and Probate Court could proceed to collect any restitution and sanction amounts, including attorney's fees, from Cooperstein. Cooperstein appealed both rulings. He asked the bankruptcy and district courts to keep the stay in place pending his appeal, which both those courts denied. No surprise. He then petitioned us to impose our own stay. We construed that petition as a writ of mandamus and denied it. The man is tenacious. In the meantime, Cooperstein missed his September the 18th contempt hearing, resulting in another arrest warrant for his 7th contempt for those counting. Wow. 7 contempt citations. 7 contempt citations. That was the last straw for MassHealth and the estate. They moved the district court to dismiss both appeals based on the fugitive disentitlement doctrine, which allows court to dismiss the appeal of a fugitive who's still on the lam. MassHealth, joined by the estate, argued that by flouting the probate court's orders and evading arrest, Cooperstein had become a fugitive from justice. Let's learn a little bit more about this fugitive disentitlement doctrine. Federal courts have discretion to dismiss an appeal without hearing the merits if the party seeking relief is a fugitive while the matter is pending. This so-called fugitive disentitlement doctrine is one of many tools, like the power to dismiss a case for failure to prosecute, to punish contempt of court, or to vacate judgments gained by fraud that spring from federal courts' inherent authority to protect their proceedings and judgment. Maybe he thinks contempt citations are like, one cancels the other. So if he gets to an even number, they cancel. Maybe that's the theory. Maybe he's just hoping for one more contempt, so they'll cancel each other out, because that's how it works, right? If you get an even number, they counter each other. However, discretionary dismissal is a severe sanction that cuts hard against our strong preference to decide disputes on the merits, and principles of deference counsel restraint when using inherent power forged by unelected judges. The fugitive dismissal rule, like any such power, is limited to the necessity giving rise to its exercise. All that being said, we trust the district court to weigh these interests and determine what's necessary to serve them within reason. And as any appeal from discretionary dismissal imposed as a sanction will reverse if the judge abused discretion, but affirm if not. All in all, the abuse of discretion standard is not appellant friendly, and a sanctioned litigant bears a weighty burden in attempting to show the abuse occurred. As we explained, Cooperstein meets that burden here. So Cooperstein, the guy who has been arrested or arrest warrants have been issued multiple times with 7 contempt citations, has managed to show the district court engaged in abuse of discretion. So I guess it goes to show procedural due process really does protect us all, even the lowest amongst us. So I guess we can take some comfort in that even Cooperstein is entitled to his day in court, which hopefully will come very soon. Cooperstein is bewildered at the suggestion he's a fugitive. According to him, he's not evading arrest. When MassHealth filed its motion to dismiss, he was at home in southeastern Massachusetts. It's not his fault the sheriff could find him. I mean, you could just turn yourself in if you're aware of the arrest warrants. And, being an officer of the court, you want to give effect to judicial process. So, you could turn yourself in just, as a suggestion. Despite 7 contempt orders and an outstanding arrest warrant, which Cooperstein does not dispute he knew about, Cooperstein remained a no-show in the probate court. And so far as the sheriff could tell, he's abandoned his house. Wherever he is, Cooperstein is hiding from an arrest to shirk the probate court sanction, and that makes him a fugitive. The court does not believe that he's just an innocent party, and this is all a mistake. Neither do I, really. However, unlike the predicate case called Goya, Cooperstein was a fugitive from the state court judgment, not the bankruptcy or district court's judgments, whose orders he never disobeyed. So the third argument that the district court could not dismiss its case to help enforce the state court's orders cut more ice. A federal court's discretion to dismiss a fugitive case flows from its inherent power to protect its own proceedings and judgment, not those of another court. The district court dismissed Cooperstein's appeal because he failed to show in the Bristol probate court, and that made that court's judgment uncollectible. And that is the rub. So the specter haunts us here. In this case, dismissal did not serve the original reason for the fugitive dismissal rule, to ensure the courts don't waste their time affirming a judgment that can't be enforced against the absconder. Here, though, the district court, even if it affirmed and the automatic stay remained lifted, could not have ordered Cooperstein to pay the state court judgment. Though Cooperstein's resistance hobbled the probate case, it did not undermine the federal district court's proceedings or judgments. It did not delay the appeal, skew it in Cooperstein's favor, or handicap the estate or MassHealth's bid to lift the stay and to keep it up. True, Cooperstein's appeal seeks relief from the probate court's order. He asked the district court to reinstate the stay and to stop the probate court from enforcing them. Unlike in Goya, Cooperstein's merits argument that his bankruptcy petition stayed the state court's efforts to collect the contempt citations is a fair one. Several judges in this circuit agree with him. See in Ray McKenna, holding proceedings to enforce and collect monetary sanctions are stayed by a bankruptcy action. That a debtor hasn't paid his state court debts outside the bankruptcy process can't be the reason we decline whether he's supposed to do so in the first place, lest we create a fugitive exception to the automatic stay without analyzing the statute. Let's be clear, none of this excuses Cooperstein's misconduct, which has a long, harmful history. By the state court's telling, he and Sheedy ripped off Thuribue, executed 2 sham deeds, one of which he illegally notarized, then, spurning 2 years of court orders and arrest warrants, installed 2 rounds of tenants, milking over $50,000 in rents and keeping the money to this day. By the time he filed his appeal to the district court, Cooperstein's serial contempt of state court had already drawn this dispute into a 3-year battle to enforce the probate court's judgment. The estate lost funds that could have gone to Thuribue and MassHealth, but for Cooperstein's repeated refusal to obey the probate court's order. Without a doubt, Cooperstein's contemptuous behavior has caused the estate court counts to mount. But unless the district court or we reinstate the automatic stay, it's the probate court's prerogative to decide how to enforce its own orders and punish disrespect for them. This is a frustrating case for MassHealth, the beleaguered probate estate, and for most of all, Carol Thibault. The appellees won in state court but still haven't been able to collect their judgment. As the bankruptcy court found, the code might clear a path for the state court to enforce its orders, but the district court's inherent power to protect its own proceedings is not implicated here, and so we must reverse and remand for the district court to decide the merits of the Cooperstein appeals. So that is the case of In re Donald Cooperstein in the United States Court of Appeals for the First Circuit. In this case, we learned that Cooperstein engaged in a scheme to defraud. He purchased a home fraudulently, executed two sham deeds, one of which he illegally notarized, and then disobeyed several court orders, including multiple probate and state court orders. Four arrest warrants have been issued for him, and 7 contempt proceedings have been issued against him. And in order to shuck his responsibility, he went to the federal district court, because he thought the automatic stay would prevent the orders from being enforced against him. However, the district court has removed the stay and the house has been sold. However, Cooperstein himself is nowhere to be found, despite multiple attempts to locate him. Even though Cooperstein himself says he's not a fugitive, he'd be happy to be arrested if only they could find him. So, whatever, I guess. But the court here rules the court below acted improperly because it dismissed the appeal on face rather than on the merits, because it ruled that he was a fugitive from law. However, his fugitivity applied only to state court proceedings, not federal court proceedings. At least as far as the federal court tells it, he had fully engaged in all of the federal court proceedings that were available to him. So the federal court could not rule him a fugitive from their justice and could not enforce the state court proceedings against him. So this will be sent back down to the decision below for further findings on the merits of the issue, which seems somewhat moot in light of the court sale, but that's where we are. And we will see if Donald Cooperstein ever sees justice, and that is the end of this case.